I'm doing a speech on McCulloch versus Maryland. Taxation of the federal government. Does the federal government have superior power to the state governments of the country? In 1818, Maryland's state legislature passed the law to start taxing U.S. federal banks within their boundaries. The Constitution covers that Congress has the power to control the taxation and expenses over the states, although it is not clear on if the federal government has the power to create its own branches of bank. The case against the taxation of federal banks began in Baltimore, Maryland. The state gave the option of the out-of-state banks paying $15,000 yearly and having a state stamp on all of their papers issued. It was either this or going out of business. I wonder which choice that most of them picked. The state of Maryland filed a suit against one man working in one of the 18 branches that are scattered across the nation. James William McCulloch was a cashier/manager, I don't know which, you tell me, for one of the branches of the federal bank when they passed tax law. McCulloch refused to pay the tax to the state government and refused to use a stamp. When McCulloch was fined $2,500 for violating the tax statute, he went to the Supreme Court about his case. The case was brought up because Maryland sought out that the Constitution never specifically says that the federal government has the power to create its own branch of national banks. Maryland wanted to declare that the federal government creating banks was unconstitutional. The federal government wanted to declare that no state could tax federal establishments because the Constitution gave Congress the higher authority over states when it came to this matter. The appellant was James William McCulloch. The appealee was the state of Maryland. Lawyers, chief lawyer for the appellant, who was James William McCulloch, was Daniel Webster. Daniel Webster was an attorney and served as legal counsel in several cases that established important constitutional proceedings that bolstered the authority of the federal government. The chief lawyer for the appealee was Joseph Hopkinson. He was elected as a Federalist to the 14th Congress. He re-elected to the succeeding 15th Congress. Both of these lawyers were associated in earlier the Dartmouth College case. That's another story. Justices for the court, which is basically court justice: Gabriel Duval, William Johnson, Henry Buckfalvis Livingston, John Marshall, who was writing for the court, Joseph Story, and Woodrow Washington. I don't know if he's related to George Washington, don't really care. In the United States Constitution, Article 1, Section 8, Clause 1, the first thing it says in the giving powers to Congress is to lay and collect taxes, duties, imposts, and excises, to paying the debt and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. The federal government has the power to create and collect taxes issued. They use the money from the taxes to provide for the military defense and general welfare of the country. It was another check placed on the legislature in order to keep a larger state from gangling up to levy state taxes, benefiting them at the expenses of the remaining smaller groups of states. This was a part of the Constitution that gave the federal government supreme power over the states when it came to taxing and collection. This case was argued against the federal government and the state of Maryland on who was unconstitutional. Maryland took the Thomas Jefferson approach on their case. Joseph Hopkinson's argument was that the Constitution was never specific on whether or not that the federal government could authorize the creation of national banks and thus was unconstitutional. Maryland also saw the necessary and proper clause as a way to restricting the federal government. This permitted Congress to seek an objective that is within the enumerated powers as long as it is somewhat related to the objective and not forbidden in the Constitution. The thing is, the first U.S. national bank was created in 1791. It was justified as an implied power of the federal government in collecting taxes and providing for a single currency for the country. As time went on, many other banks were created and grown in states, thus the states could now function on their own without the use of federal banks. When Congress set up the second bank in 1816, it did not give the power to establish branches, and when they were established, it could not claim to be excused from the state's tax, as that would be an invasion of state control. The federal government took the Alexander Hamilton approach on their case. Daniel Webster's argument was that the state of Maryland did not have the power to interfere with the taxation of the federal bank. They had implied power, not specifically stated in the Constitution, that in order to uphold Article 1, Section 8, Clause 1, a national bank would be the most appropriate tool to help the government carry out its powers. It was the best way to collect taxes, further the nation's welfare, and to conduct war. Therefore, the federal bank is constitutional. The court decided on March 6, 1819, that Congress had the power to charter the bank. Chief Justice Marshall supported the court's decision and had three conclusion reasons. The government proceeds from the people and binds the state sovereignties. Therefore, the federal government is supreme, based on the consent of the people. Although Congress is limited in power, it is supreme to any other government within the power given to them. Congress is bound to act under explicit or implied powers of the Constitution. Practically, if all the meanings from the powers listed were strict and not able to be bent, then we would not be able to understand or embrace the Constitution. It is impossible to write down all the specific rules of the Constitution and let it be successfully documented through time. Although the word bank is not used in it, there are expressed powers in the Taxing and Spending Clause, the article that I've been talking about. Not specifically stating it, Congress has the implied power to create the bank in order to implement the express powers. He also concluded that Maryland's viewing on the necessary and proper clause in the subject had a narrow interpretation of the clause, saying the clause is listed between the powers of Congress, not the limitations. Marshall also established that the taxation on the bank was in violation of the Constitution. The Supremacy Clause states that state laws that comply with the Constitution and succumb when there is a conflict. If states were permitted to continue their acts of taxing, then they would destroy the institution created by federal governments and oppose the principle of federal supremacy, which originated in the text of the Constitution. That's it.